I am thrilled to see so many of you here today from across the country. Good morning to those of you on the West Coast. My name is Jennifer Nagda, and I'm the Policy Director at the Young Center for Immigrant Children's Rights. I have the honor of moderating today's webinar and introducing you to our fantastic speakers. But before we get started, I wanted to share some quick program notes. First, we will be recording today's webinar and following up by email in the coming days with the recording and information about ways that you can continue to uplift and support this work. Second, we've set aside time before the end of today's webinar to answer questions and even to strategize with you. So please, at any point during today's webinar, we encourage you to submit questions using that Q&A button at the bottom of your screen. The chat is disabled during this webinar, but the Q&A feature will remain open. And during the webinar, we will compile your questions and comments so that our speakers can spend some time addressing them at the end. With that, I want to jump right in and introduce today's topic. As you may know, the Young Center at NIJC have decades of experience advocating for the rights of immigrant children and communities. The Young Center created the model for and remains the only organization in the country providing independent child advocates to children in immigration proceedings. The role of child advocates is to first identify and then fight for the best interests of unaccompanied children. We do that with any agency or person making decisions about the child, from ORR to DOJ to DHS to Counsel for the Child. Just to be clear, we define best interests as set forth in the Convention on the Rights of the Child, which is centered on children's expressed wishes, their safety, and their rights to family integrity, to liberty, to development, and to their identity. Our work as child advocate informs our policy advocacy, where we seek to create systems that treat immigrant children as children. Our partners at NIJC offer a wide range of legal services to over 10,000 low-income immigrants, refugees, and asylum seekers every year. They provide critical legal services to detained and recently released unaccompanied children, including helping children understand their rights when they arrive in the U.S. and representing them in immigration court and before U.S. Citizenship and Immigration Services. NIJC's direct representation of immigrant children, adults, and families informs its litigation and policy strategies to advocate for an immigration system that upholds due process, human rights, and racial justice. Given that collective work, it is no surprise that our two groups came together to co-author this report to identify the harms of the government's behavioral reporting system for children in its custody and to recommend strategies for advocacy both in individual cases and for systemic change. Significant incident reports, or SIRs as we refer to them, are the foundation of this reporting system. SIRs are used by officials and staff within the Office of Refugee Resettlement, or ORR, which is the federal agency responsible for the care of unaccompanied children. Those officials often write up children for minor rule infractions, or what anyone else, especially those of us who are parents, would consider developmentally appropriate behavior for children and teenagers. They may use these write-ups to justify a child's transfer to a more restrictive facility, to delay a child's reunification with family or their placement into foster care, and they may do so without realizing that their report may ultimately undermine a child's petition for discretionary relief, like asylum. We hope that a better understanding of how this system operates will help you to challenge SIRs that undermine clients' interests. At the same time, we hope you will be inspired to join this effort to fundamentally reform how ORR responds to children in crisis and how the agency documents children's behavior so that federal policy and practice actually meet the needs of children in custody. Today, you will hear from the two authors of the report, Jane Liu and Azadeh Erfani. Jane is the Young Center's senior litigation attorney. She directs all of our work on impact litigation and federal regulations. She is an advocate's advocate. She centers children's voices and the experiences of our child advocates in all of her work, and she brings a wealth of intersectional expertise to her advocacy. Azadeh is the senior policy analyst at NIJC and a tremendous partner and ally. Azadeh leads NIJC's response to regulatory attacks, asylum, and immigrant children and youth's rights, and she has an impressive background in defending detained children and youth in secure custody from deportation. I am so excited for you to hear from these two incredible lawyers, advocates, and champions for immigrant children. Jane and Azadeh, the mic is yours.
Thanks, Jennifer. We wanted to begin today's webinar with just a brief overview of unaccompanied children and some important characteristics to keep in mind as we talk about the government's incident reporting system. I think that many of you are familiar with who unaccompanied children are. Children who are designated unaccompanied are under immigration law are taken into government custody and placed with the U.S. government's Office of Refugee Resettlement, what we call ORR, until they are reunited with family members or released to other sponsors in the United States. It's important to keep in mind that unaccompanied children face numerous challenges and stressors. These challenges and stressors are critical to understanding some of the problems with ORR's incident reporting system. Many unaccompanied children have experienced intense trauma, harm, and violence. Many have experienced traumatic events in their countries of origin, which may be the reason why they are seeking protection in the United States. Many have also experienced extremely difficult and dangerous migration journeys to the US, during which they were exposed to violence and harm. And then once they get to the US border, children may also experience additional trauma and stress. For instance, some children may experience separation from parents, caregivers, or family members, which can be extremely traumatizing. And then many children, well, all unaccompanied children have to go through the Customs and Border Protection custody before they are transferred to ORR custody. And the conditions of those facilities can also be very difficult for children, as those facilities are not equipped to meet the needs of children. Entering ORR custody can also be very stressful and disorienting for unaccompanied children. Children have to adapt to a new unfamiliar congregated care setting. They have to interact with adult strangers that they do not know. They experience significant restrictions on their movement and freedom. Unlike, it is the level of restriction is unlike anything that they've likely experienced before. They face language and cultural barriers. Most children are placed in large-scale facilities with more than 25 children, which is far from the family-based settings where children thrive. And as a result of these kinds of conditions, children often experience mental fatigue due to detention. It's what we call detention fatigue. And this detention fatigue arises as a result of children having long stays in custody, facing delays in reunification with family and release to sponsors, delays or denials in placements in foster care, placements in more restrictive settings. And as a result of this detention fatigue, children experience anxiety, depression, symptoms of post-traumatic stress disorder, and overall children often feel helpless and feel a lack of agency under these conditions. And those things are exacerbated when they don't receive the individualized trauma-informed care that they need. Children also experience stress and fear due to the uncertainty around their status. They fear imminent deportation, and they have anxiety around their ability to remain in the United States and reunite with family members. All of these stressors, all of these traumatic experiences result in a cumulative trauma that has a building block effect on children's mental health and physical health. And this can have a significant effect for children. It can result in difficulty sleeping, trigger responses to reminders, difficulty completing tasks, and difficulty engaging socially. So all of these things are what unaccompanied children are experiencing when they are in custody. Despite all of this, I also want to just note that unaccompanied children are able to adjust and adapt positively when they receive the care and support they need. And what they really need is a comprehensive trauma-informed approach that is strength-based, which focuses on their strength, focuses on family and other protective factors rather than emphasizing deficits and being punitive. And with that, I'll send it over to Azadeh.
Thank you, Jane. So I'll shift us over to talking a little bit about the Office of Refugee Resettlement, or ORR, recognizing that many of you are very knowledgeable about this. We wanted to actually focus in on ORR's role, not just as the caregiver for children, tasked by Congress to take care of them and to have custody of them until they're safe release to family, but also in terms of their placement. And the chart that you can see on this slide basically summarizes what we are trying to, what background that we think is really important in terms of understanding some of the effects of SIRs. So the vast majority of children who enter ORR custody enter at step 2 here, shelter, or what Jane has referred to before as large-scale facilities and basically congregate care. And but it is incredibly easy for children to get stepped up and much harder for them to actually go back down this ladder in terms of levels of restriction. All of this has to do with the fact that ORR keeps tabs on kids on a daily basis on what they say, what they do, and basically makes assessment as to what level of security they should be assessed at, and how soon they can be released to their family. That infrastructure, which we expand upon a little bit more in Appendix B, makes significant incident reports basically front and center to the process that ORR undertakes in making these placement decisions. And what you see on the far right, the red box basically refers to the fact that as kids approach their 18th birthday, they are at risk of being transferred into ICE custody, with ICE reviewing SIRs or incident reports scrupulously. So, but before moving on to the next slide, I want to draw attention to what's at the bottom left, which is basically the gold standard in child welfare, family-based placements or long-term foster care. That's where kids are best treated if they don't have a family to reunify with. And at the same time, it is a really difficult placement to reach if kids already have incident reports on their file. So these incident reports can create basically a barrier as well in terms of the ideal placement that children need. So on to the next slide. We wanted to talk a little bit more about what SIRs are. And you can see a whole lot of different words on your left, some of which are directly words from ORR. So ORR has called these SIRs incomplete and inaccurate in its own policy manual. And that refers to the fact that, these incident reports are often amended. They're far from complete documents. They are written very quickly, often, through a rushed process of 4 hours or 24 hours after the incident, by staff who are feeling a lot of pressure to document what happened and their perspective and share it up the chain in ORR as soon as they can. You also see a lot of missing details in these SIRs. They often lack any context in terms of the child's behavior, making it look like the child's behavior was erratic when there was a lot of context that you could have provided in terms of, the child just received really bad news from home country, or the child was having a manifestation of their mental health symptoms. those kinds of things are often missing when people are drafting these incident reports. And the other thing is they're very one-sided. Kids don't get to weigh in. Kids don't have a voice in incident reports. Their lawyers are not advised that these incident reports are filed. So for the most part, it really reflects the perspective of the staff member who's writing them. And it is up to ORR to basically try to amend them after the fact to try to add any supplemental information. But the incident report itself could be basically rife with hearsay, rife with all sorts of inaccuracies, and stay within the child's record for the duration of their time in ORR custody. And in terms of the types of incidents that they document, I would recommend to take a look at our Appendix E in the report, which includes 6 sample SIRs that we have that we redacted to share with you all, because oftentimes people are wondering, what do these forms actually look like? And these forms, document a lot of these types of trivial things that we have been talking about. So rule infractions like getting up to get food too early at a time where it wasn't allowed, or going to the bathroom, breaking a rule in terms of how soon they get to go without permission, sharing water, sharing food, engaging in horseplay, having a temper tantrum, having behavior that basically is testing boundaries, and and manifesting different symptoms of trauma, grief, or disability, as Jane had mentioned, despite the fact that this population has a lot of those and comes with that already into those detention centers. But I will add that it's not always what kids do. It's also what they say. So incident reports could be filed when there is no incident in the first place, when it just has to do with what the kid has disclosed. So the kid may disclose that they were the victim of abuse back in home country, or that they fell prey to gangs or cartels back in their home country. So nothing that actually is documenting an incident that happened in the facility, but still something that ORR is going to write up and put in the child's record and use as an assessment in order to determine whether the child should be placed in a higher security level, whether there should be extra steps before the child is released to their family, etc. So it has a lot of different ripple effects that we'll be talking about. And, our report is peppered with kids' poems, quotes, testimonies from years of litigation where they have raised a range of systemic issues with ORR, including the problems that have been raised with these incident reports. So I wanted to take a moment to actually read this quote. It says, "I thought I was going to go with my mom, but I was informed in the car that I was going to another shelter, and I was asking them why. They answered that I could not be in that program," meaning the shelter that she was already at, "because I had too many reports. I asked them, what reports? Because I have never been warned that there were reports against me. They gave me no more explanation or opportunity to defend myself. I started to cry because I was frustrated, and also because I did not think it was right that I was suddenly moved." So what this quote makes clear is that that these SIRs are often filed without children's input and knowledge, and they also don't require any kind of process by which they get to weigh in, either through their attorney or themselves, or through their child advocate, despite the clear implications on their cases and time in custody. Because remember, when a child is transferred to another facility, they have to start all over again with a new legal service provider most of the time. So in essence, they have to tell their story again and open up again and try to build rapport and trust with new people, even though they feel that their own trust has been violated through the system as they know it. And the current system basically fails to give them a voice and support them in terms of understanding the decision that's been made on their behalf. And the last thing I'll add is that, it's really frustrating for kids to feel like they are being branded. And that's sort of what you see in this moment. There's been very little communication about what's happening, but these reports are hanging over this kid's head and essentially influencing how she is being viewed by ORR and how, ultimately she could view herself, because this system is branding her in this particular way. So shifting to the next slide, we thought it was important to sort of dig out a little bit of the statistics that have to do with SIRs. And what you see here is actually data that ORR itself has shared. And basically it shows that SIRs are taking up an exorbitant amount of ORR staff time and resources. So for the fiscal year of 2019, ORR facilities submitted over 100,000 SIR forms. That includes the SIR forms themselves or their addenda, for less than 70,000 kids in their custody. And this is what's staggering, really. They used up over 34,000 hours within a year. And if you're wondering, that's the equivalent of 4 years within one of staff time. So it's really taking up many, many resources that ORR could be dedicating to children. And it really does little to improve the conditions that kids are facing. Most of the time, our staff are facing layered requirements and basically are forced to use a compliance mindset, right? Like, it's better to file an SIR than not to file one, even if that means over-reporting, even if the incident itself is not significant or an incident, because of the many rules that they have to navigate. But that means that they are often also missing the fuller picture in terms of their child's needs. So there's very little focus on SIRs in terms of crisis prevention, in terms of de-escalation methods, and all of these resources are poured instead into filing these reports and forms. So the main question I want to raise here is, why, right? Why would we dedicate this much time, this many resources for something that does little to help children, but has many devastating consequences? And with that, I'll pass it over to Jane to discuss further how these reports are getting used.
Thanks, Azadeh. So we wanted to just go into a little bit more detail about the negative consequences of SIRs for children. Although our ORR policy states that incident reports ensure that significant incidents are responded to in a way that protects the best interests of children, what we have found is that very rarely do SIRs indicate an individualized response by ORR or facility staff after the incident to address the child's specific needs. Instead, what we see is that SIRs have numerous harmful consequences for children. And essentially what SIRs have become is a driving force of ORR's disciplinary structure rather than a tool to ensure that children receive the care that they need. We sort of list a number of different things that SIRs can cause. First, SIRs often lead to transfers to more restrictive placements and prolonged custody in a number of different ways. ORR facilities often respond to SIRs by stepping up children to more restrictive placements that are rarely able to address a child's trauma or mental health needs. And please keep in mind that the a child has no opportunity for a hearing before they are stepped up to a more restrictive placement, and a child's attorney is often not notified that ORR plans to step up a child. On top of the fact that the SIRs themselves, children are not made aware of or notified of. SIRs also lead to denials of step downs to less restrictive placements, meaning that if a child is in a more restrictive placement, they would try to be stepped down to a less restrictive placement, but SIRs can often prevent that step down. ORR will often deny step downs unless a child has spent at least 30 days in restrictive placement without any significant behavioral SIRs. And even a minor incident can restart that 30-day clock. Incident reports can also lead to delays and denials of releases to sponsors. They're used to justify home studies, which also can result in delays in release and even denials of release. We've also seen SIRs that delay or lead to denials of placement in shelters or foster care settings. We've seen shelters and foster care providers that have relied on SIRs to deny placements to children. They will say that they cannot accept the child for placement because they can't meet the child's needs, and they will rely largely on the child's SIRs and the child's case file to justify that decision. We've also seen denials of SIRs lead to denials of placement in the unaccompanied refugee minor program, foster care program, which provides foster care and services to some eligible unaccompanied children. As far as we know, the unaccompanied refugee minor program often requires a child to have a period of 60 to 90 days without any behavioral SIRs in order to access the program. And finally, we also see that SIRs just fundamentally undermine the relationships between facility staff and children. Children frequently report that they've been threatened with SIRs, and it becomes part of the disciplinary punitive system of ORR custody. And then on the flip side, staff often feel like they have no choice but to file the SIRs in order to comply with ORR policies. As a result of this, children lose trust in staff, and that's particularly the case when facility staff are required to document confidential information that a child discloses to staff in SIRs. That deeply undermines children's trust in staff. SIRs also can lead to transfers to adult ICE detention upon a child turning 18. Prior to a child's 18th birthday, ORR makes a recommendation to ICE, which includes an assessment of whether the youth poses a danger or flight risk. And ORR frequently either provides copies of SIRs to DHS or bases its recommendation to ICE on SIRs. We've also seen SIRs being used against children in their immigration cases. ORR regularly shares SIRs with DHS pursuant to information sharing agreements. And under the Biden administration, we've seen a new info sharing agreement that limits the types of info that can be shared, but we continue to see a wide array of SIRs still shared with DHS. And on top of that, there are a lot of loopholes to these policies. And given that ORR facilities continue to share many types of SIRs that they're not required to share. And we've also seen that ORR has no checks in place to prevent or remedy inappropriate information sharing, including the inappropriate sharing of SIRs. Finally, we've also seen SIRs lead to calls to police and the criminalization of children. What SIRs ultimately result in is they undermine staff's ability to troubleshoot situations without viewing them as incidents that need to be elevated. And many behavioral incidents could be avoided with implementation of effective de-escalation techniques. But rather than encourage de-escalation, we've seen SIRs followed by calls to local police or involvement of law enforcement. And then when police arrive, they're rarely able to communicate directly with the child, and they often view the child as a threat or have implicit bias, which results in children being arrested and even charged with criminal offenses. Most of these arrests don't result in criminal convictions, but these arrests have harmful consequences for unaccompanied children, resulting not only in them being held in criminal custody, sometimes for long periods of time, but it also can have disastrous effects for children's immigration cases as well. And I wanted to talk next about our survey, which our report talks about in more detail. In the summer of 2021, we conducted a survey of a variety of stakeholders who work with unaccompanied children, including staff in OR facilities, legal service providers, and attorneys. And what we found in the survey results was three overarching patterns that sort of we've already discussed a lot of these overarching patterns, but the survey results confirmed this. The first overarching pattern we found is over-reporting, that there are a lot of SIRs report minor infractions and behavior that would be completely appropriate if it had occurred outside of OR custody. For instance, children failing to follow facility rules, children displaying behavior that's disapproved of, but developmentally appropriate, such as some defiance and boundary testing, horseplay, tantrums, foul language. We also, survey results also showed that SIRs often lack context, critical context for understanding behavior or conduct of children. For instance, SIRs often capture behavior that is triggered by detention conditions or trauma, and it often doesn't include this critical context. What we find instead that there's sort of mischaracterizations of behavior, or for instance, children expressing a desire to reunite with family or be released. We see that often as children being characterized as flight risks, which can lead to more restrictive placements for children. And we also see a lack of context in terms of children's mental health conditions and disabilities. None of that information is included in SIRs. And so SIRs often provide a very one-dimensional sort of incomplete picture of what's going on with the child. And finally, as we've already talked about, and the survey findings showed, SIRs are a pipeline to more restriction. Survey respondents confirmed that SIRs fuels placements in more restrictive settings and can prolong custody rather than bolster trauma-informed care for children. As Azadeh mentioned, we have included in our report direct quotes and poems written by children, and we felt that was really critical because we wanted you all to understand what it's like for children to receive SIRs, to learn about SIRs, and in the context of OR custody. And this poem is this slide shows an excerpt from a poem by an unaccompanied child held in secure detention in Shenandoah, Virginia. And it reads, "It doesn't feel good to know that everyone is afraid of you. It turns you into a monster, which is what they think of people like me. They imagine that everything I did out of fear." So our report underscores the need for a complete transformation of the agency's reporting system to truly center the needs and safety of children. Our report, in doing our report, we really wanted to provide concrete recommendations for ORR to overhaul its system. And I'll talk about our first four recommendations. The first one, and which is one of the most critical, which is that we recommend that OR engage child welfare experts, child psychologists, de-escalation and crisis prevention experts, and former unaccompanied children to inform a new approach to incident reporting. Our second recommendation is that ORR center trauma-informed care in all aspects of its system in order to prevent and reduce the occurrence of serious incidents. It's critical that ORR implement trauma-informed care across the system, not just in one section or just provide a training. Every aspect of its system should be focused on providing individualized trauma-informed care to meet children's needs. And part of that we recommend formally training all staff, facility staff, in not just trauma-informed care, but crisis prevention and effective de-escalation techniques, and for ORR to adopt metrics to measure staff implementation of that training. It's critical that they not just do the training, but to ensure that staff are effectively implementing those trainings. And again, I want to emphasize that the goal should be to reduce the number of serious incidents, and comprehensive trauma-informed care is critical to achieve that goal. Our second recommendation, which sort of dovetails with our first recommendation, is for ORR to prioritize the use of incident reporting to evaluate and monitor children's needs, staff response, and facility-wide issues. ORR's response and follow-up to incidents should be the focus of its incident reporting system. ORR should use its incident reporting system to assist in evaluating whether a child is receiving the services and support the child needs so that the child can remain in the least restrictive setting. ORR should also use incident reports to monitor for systemic issues and sort of flag those things so that they can make changes as needed. And ORR should also ensure that de-escalation techniques are documented with specificity, that critical context is included in SIRs, and they should also ensure independent monitoring and oversight to ensure that its SIR system or its incident reporting system is being implemented effectively to meet its goals. Finally, as Azadeh spoke about before, with over 100,000 incident report forms filed in 2019, it's clear that there's over-reporting occurring in terms of ORR's incident reporting system. And so we recommend that ORR limit its incident reporting to serious incidents and take affirmative steps, including putting in policies and procedures and guidance to prevent over-reporting. Incident reports should be limited to serious incidents, which means those that involve significant injury or significant risk to the safety and health of the child or other children. And they have to provide clear guidance and policies to limit the types of incidents which facilities should report. And then ORR should monitor incident reports to prevent over-reporting. I'll pass it along now to Azadeh to go through the final three recommendations.
Thank you, Jane. So yeah, as you have learned today and can learn more from our report, we think that holistic review is generally an exception and not the norm. So that's largely because SIRs take up so much focus and attention within ORR. So that's why our fifth recommendation here is to really prevent incident reports from being used as a form of discipline or punishment, and instead conduct this holistic review that children need when making placement and reunification decisions. So even though children are rapidly evolving, incidents can happen 2 months ago and should hardly define a child for the rest of their time in ORR custody, but because of the process that ORR has currently, they still do. And the current process is essentially indelibly marking children and potentially marking them as quote unquote problem children, leading to disciplinary measures and more restriction and step-ups, which in turn end up aggravating kids' mental health further, as Jane had explained. And we hear that from children directly, right? They ask, why do I have to go in a place that looks like jail when everybody else is getting to have more playtime, more outside time? What have I done to deserve this? And sadly, in some cases, these punitive measures also end up impacting their self-image and self-worth, and they end up internalizing the way the system is seeing them instead of building on their own strengths and resiliences, and essentially tapping into tapping into another part of themselves as they try to heal from their trauma. The next recommendation is implementing safeguards so that children have an opportunity to be heard, including notifying and providing copies of SIRs to children and their attorneys and child advocates if one has been appointed. And at bottom, that's about transparency and process. It's far from a given that children's attorneys and legal service providers even learn of SIRs. When they request a child's file, which can take weeks or months to get, attorneys are not guaranteed to receive these incident reports. However, if you turn again to Appendix E, you'll see at the bottom that there's a whole bunch of people who get notified at high levels of ORR leadership as well as ICE, but not the very people who are tasked with defending children's rights. So we propose different steps that ORR should take in order to change this and ensure that children's voices are heard with the support of counsel and their child advocates before these reports end up harming them. And the last recommendation has to do with preventing the disclosures of SIRs as well as other portions of their files to the Department of Homeland Security or ICE or USCIS, unless it's contrary to their best interest. So speaking of ICE getting notified and not attorneys, it's a perennial problem. These children basically have their reports shared when they're approaching the age of 18 pretty routinely under the guise of a post-18 plan that ORR is sharing with ICE. Nothing requires that post-18 plan to include SIRs or to list SIRs, much less attach them. But it is very routine for those to be shared and for ICE to take them into considerations. And additionally, Jane had mentioned some loopholes that remain even under the Biden administration, where basically ICE is still sharing certain incident reports with ICE, who in turn is able to use them during their removal proceedings or in making custody decisions. So in the very, very rare cases where disclosure is needed, children and their attorneys should be notified immediately, and basically ORR should be prioritizing the implementation of a firewall at every step. So with that, we wanted to close out with a very basic slide where we're just touching base on what you can do with all this information. Obviously, ORR changes its policies a lot on SIRs and is also expected to roll out some new regulations regarding the care and custody of unaccompanied children. So we recommend that you stay connected with us because there will be opportunities in the future to weigh in and call for the overhaul of the current incident reporting system and its replacement with a comprehensive trauma-informed system that is actually serving children's needs. And of course, if you serve unaccompanied children, as many of you already do, we really hope that this report is a resource for you and an educational tool for you to provide the systemic context for the use of SIRs and their adverse impact. So use them for the edification of the court, for USCIS. There are so many resources for you to zoom out and not allow basically these agencies to take these incident reports at face value. So there's a lot that we hope that this opens up in terms of those opportunities as well. And with that, I will turn it back to Jennifer.
Azadeh and Jane, thank you both so much. As you know, I saw drafts of this report, early drafts, mid drafts, late drafts, the final report, but listening to you speak today and walk through how this all plays out deepened my understanding of just how problematic this is and just how compelling it is to address these issues now and effectively. And to that end, we have some terrific questions from folks who have been listening, and I will read a couple of them out to you, and I'm hoping that the two of you could answer or tag team, but let me start with this one. one of the first questions asked was, how do we overturn this unfair and staggering, and Mary Jane, I completely agree with that adjective, this staggering SIR system? Is there statutory or regulatory authority that we need to change, or is this an administrative construct that can be changed by the Biden administration? I know you started to tackle that a little bit in your recommendations. They were very much focused on what the Biden administration could do, but I'd welcome comments from both of you or either of you on whether you think this is best addressed through statute, through regulations, through policy, and with whom and how.
I can get us started. So yeah, ORR basically has full discretion right now in terms of what they do with respect to their policies. And part of the background that kickstarted this report is that Jane and I, basically touched base after ORR changed its rules once again in June of 2021. And that's when they added some language, for example, saying that beware, SIRs are incomplete, they are inaccurate, but that didn't change the way in which they are used and on a daily basis. So the main reason why we are calling on them to change their policies altogether, and that we think that it merits the full force of regulations as well, is these rules can be changed all the time, and they are essentially layering one on top of the other in a way that really confuses our staff. So, basically reforming, adding one more layer is not going to fix the system, and we'll keep it intact for the time being in terms of how it is actually, rolled out in children's eyes. So.
Jane, I don't see you jumping in, so I'm going to move ahead with the next question. And we had a terrific question from Lorena that started with a question about the percentage of unaccompanied Indigenous children identified in the survey. And I don't know if that's information you have access to because of the way the survey was designed. But she asked, often we hear that Indigenous children in particular do not report abuse due to language barriers. And so I'm wondering if that issue of language reporting, underreporting of issues of abuse and other harm, or other concerns raised by Indigenous children came up either in your survey or other advocacy you've done with advocates and attorneys.
I can take this and feel free to chime in, Azadeh. I mean, I really appreciate this question. And, we did not get, I don't know if it was just, we did not get that specific with our survey findings in terms of how SIR specifically impact Indigenous children. But I think it's spot on that many children in OR custody are Indigenous. One of the biggest challenges is that in terms of data on Indigenous children is that we cannot rely on any data from ORR. I don't think that there's really an accurate identification process. What we are hearing from many legal service providers and attorneys that often children are misidentified even just based on like what language they prefer to use in custody. So I would be reluctant to rely on data that's gathered by ORR. I think that data needs to be collected and to be done in a rigorous way. But I think your point, the broader point though, I think is really important because, things like language and cultural needs, differences in background or reluctance in reporting, all of those things are often not reflected. That type of context is not reflected in SIRs or even it's just not incorporated into the OR system across the board, and it really needs to be. It's how you implement a trauma-informed care system, right? You have to meet the individualized needs of the child, and that's just not really happening. And SIRs are a component of that. But I've not seen every SIR, but my guess is that SIRs almost never would indicate that a child speaks an Indigenous language or is Indigenous in background and may have different understandings or may fear reporting, may even be experiencing bullying while in custody. So there's, I think it highlights a very specific need, and just the need for trauma-informed care across the board.
Thanks, Jane. We have two more questions that I think we have time to get to, and if more, they're continuing to come in. So we'll take this right up to the hour. But the next question we have is, why not just recommend the complete doing away of SIRs? You've talked a lot about if they weren't done in this way, the amount of time that could be invested in appropriate caring for and support of kids. Is there some value to the SIR forms or to the idea of reporting in and of itself? Or is this sort of a recommendation that comes out of the sort of pragmatism of they're never going to ditch the form in its entirety? Where do you fall on that keep it or lose it continuum? And you're both welcome to answer in case you have different perspectives.
I think we're largely on the lose it front. In terms of the overhaul, that is very much what we're talking about. But there is still a place for recording when there is an incident that is occurring within a facility. Remember, kids are being held in large facilities and facilities where they are largely stripped of agency. And so there's a place for actually keeping tabs on incidents that are occurring, whether it impacts or our staff interacting with them or kids interacting among each other, and potentially, again, manifestations of their own trauma, of their own abuse coming through in their behavior. One of the things we try to demystify at the front of our report is, why do unaccompanied kids act out? It's not nothing strange. There's nothing strange about that. Children act out, and there's a lot of that acting out that is developmentally appropriate and that it aligns with the trauma that they've suffered. But it's also important to recognize that these incidents cannot be captured under the system as we have it now, where anything and everything is written down, where these incidents are essentially used to punish and discipline children as opposed to figuring out what they need. So that's why we fall under the transformative and overhaul message here, because we think there's a place for doing this right, but it's far from what's happening right now.
Yeah, and I think I just want to clarify that, we're not opposed to documentation and making sure that, significant injury to children is documented in a way that there's, sufficient monitoring and oversight of the care that children are receiving in facilities. Like I see the value in that. I think it's really the problem is how that information is being used, and particularly in how it's being relied upon to place children in more restrictive settings, how it harms kids in their immigration cases. Like that should not be the intention of documenting incidents that impact children. If a child breaks their arm, yes, I think it should be documented somewhere so that the child receives the medical care that they need and the services that they need while they're in custody. But I don't think it needs to be, then used against. I mean, I'm not saying that specific report will be used against a child, but that is not the type of report that should result in discipline to a child or anything like that. So, but I do want to put that disclaimer in because, I understand that there is some value to, documenting information about children, especially when they're being placed in the care of strangers. I can see that even being a relief to adults as well, to parents as well. So I just wanted to say that.
Thank you both. We have a great question. These have all been terrific questions. A great question from Lauren, who asked, have there been any efforts by immigration attorneys to block the use of SIRs as evidence in the adjudication of children's immigration relief applications, given the unreliability of the evidence? And if so, have those been successful? And I'll take the moderator's liberty of starting off with an answer that gets partially to your question, but is less about a merits hearing. But early on, during some of the preliminary Flores bond hearings, I had a colleague at the Young Center who was a child advocate for a kiddo in secure detention. And during the first Flores bond hearing, ORR attorneys came into the courtroom waving a huge stack of papers saying this child has 217 SIRs. And, clearly this is not a child who can be safely released into the community. And between that and the subsequent hearing, my colleague created an Excel spreadsheet that documented every SIR and what the SIRs were for and when they happened. This is a child who had experienced significant harm in home country. So many of the SIRs had to do with disclosures of abuse prior to entering ORR. And when she went into court to advocate on behalf of the kiddo's best interests and why it was not in his best interest to remain insecure, she pointed out that 17 or so of these 200 plus SIRs were maybe relevant, but that the rest had no bearing. And that was very specific to the situation of a Flores bond hearing. And that was at a very different time. But Azadeh, given your representation of kiddos insecure and in other places, or Jane, if you heard from attorneys about these SIRs cropping up in merits hearings themselves or asylum adjudications before USCIS, it would be great to know if folks have been successful in pushing back on reliance on these SIRs.
I can start really quickly. I think there's no doubt that these SIRs merit an objection for hearsay and unreliability. Whether that's actually going to have an impact is a difficult question, right? Because of the large thresholds, the high thresholds in terms of admissibility in immigration proceedings. But that doesn't mean that you shouldn't raise that. And I think in particular, the particular placement of children can be one that also merits its own sort of zooming out in terms of lawsuits that may have been documenting abuse within that shelter that may give better context for that child's behavior. So charting them out, thinking through about answers in terms of these incidents and trying to put the system on trial as much as possible is really what I would recommend in that circumstance. And again, we hope that the report is useful for that purpose.
Well, we are right at the hour. And while we have a couple more comments that have come in, I think that wraps it up in terms of questions that we can answer today. I want to remind folks that we've made a link to the report available. We've also made a link available as a survey just to provide some very quick feedback. It'll take a minute or two of your time on today's webinar and would encourage everyone to fill that out. We are hoping to engage in similar conversations with other people in a position to influence how SIRs are used, and we welcome you in that effort. Stay tuned for emails from both NIJC and the Young Center, and thank you so much for being with us today.
Thank you.